When you were in private practice, you wrote a brief in favor of forcing the Baker family, a Catholic family that owned a print shop, to print membership cards for a pro-abortion activist group. The Baker family believed that was in violation of their deeply held religious convictions. In your brief, you used strong and even incendiary language to describe the Baker family's religious convictions, referring to their views that they did not wish to actively advocate for and promote abortion. You referred to those religious views as invidious and pernicious. As you know, the very first clause of the First Amendment of the Constitution protects religious liberty. Given that history of litigating and attacking an exercise of religious liberty, how might a litigant in the Second Circuit have any confidence that as a judge you would actually follow the law and in particular honor the religious liberty protections in the Constitution?
Senator Ted Cruz delivers one of the most gripping Senate confirmation exchanges in recent memory, as he confronts a federal judicial nominee over her decades-long legal record of fighting against religious freedom. A Catholic print shop family in Vermont was once forced into court after refusing to print materials for a pro-abortion activist group, and the woman now seeking a lifetime appointment to the Second Circuit was on the other side of that fight, describing their sincere religious convictions as invidious and pernicious. Cruz goes even further, exposing remarks the nominee made at a marriage law symposium, suggesting that maybe churches should be compelled by law to change what they teach. This video breaks down every intense moment of that hearing, explaining what it means for the First Amendment, religious liberty, and the future of the federal judiciary. Let's dive right in.
Thank you, Senator Cruz. Just to put that case in context, and I don't have all the details in my mind because it was 30 years ago. It was my very first year of practicing law in Vermont. But the claim by my client was that she had been subject to discrimination on the basis of her religious conviction. In particular, she had asked to print cards for Vermont Catholics for free choice. Her contention was that the Bakers said, "We won't print these cards because we don't think Catholics can be for choice." She brought a claim for discrimination on the basis of creed, and we acknowledged out of the blocks that if the facts showed that the Bakers declined to print the placard because of their opposition to abortion rather than their belief that her strain of Catholic faith was wrong, then she wouldn't have a claim.
So hold on a second. I have to say you said that clarifies things, but if anything, that makes it worse. So your argument was that if their view was this is the teaching of the Catholic Church, then that the courts should straighten them out and say, no, you don't get to have your own understanding of the teaching of the Catholic Church. We're going to force you to say the Catholic Church is pro-abortion even if you don't believe it is. Is that right?
Senator, the applicable law as stated by Justice Scalia in his opinion in the Smith case was and remains that a neutral law of general applicability applies without...
and that's why Congress passed the Religious Freedom Restoration Act.
I understand that.
The overwhelming bipartisan majority of Congress concluded the Smith case did not adequately protect religious liberty. You likewise, during a marriage law symposium, said, quote, "Long after every state in this country allows same-sex couples to marry, there will still be churches that decline to recognize or celebrate same-sex marriage. And we're not suggesting that should be otherwise." Well, maybe it should be otherwise, but that's not our mission. I find it quite astonishing as an advocate that you're suggesting that the law has purview to force pastors and priests and rabbis to change what they teach as a matter of faith if it does not fit a political position that you happen to support.
Senator Cruz, I would agree with you. That is not my position. I'm not familiar, as I sit here, with the exact context of those remarks, but when I was an advocate, our position was always that the debate about whether a particular religious community should or shouldn't recognize marriages between same-sex couples was for the members of that religious community to decide. The question of whether the law should recognize marriages between same-sex couples was the only issue of concern for our advocates.
What the American people witnessed in that Senate hearing room was not simply a political exchange. It was a defining moment, a moment where one man, armed with the Constitution, armed with the facts, and armed with an unshakable commitment to the First Amendment, stood up and said, "Enough." Ted Cruz won that exchange, not on points, not on technicalities, he won on principle. He walked into that hearing room with the receipts, he had the briefs, he had the quotes, he had the record, and when the nominee attempted to soften her history with the passage of time, claiming the case was 30 years ago and that she did not remember the details clearly, Cruz did not flinch, because the words she wrote do not expire, the briefs she filed do not have a statute of limitations, and a lifetime appointment to the federal bench demands a lifetime of accountability, not selective amnesia. Think about what Cruz accomplished in that chamber. He exposed a nominee who had once stood against a humble Catholic family, people who simply wanted to run their small business in accordance with their deeply held faith, and described their sincerely held religious convictions using language more suited to a political attack than a legal brief. He forced the entire Senate, and the entire nation, to confront the question of whether someone who views religious belief with that level of contempt belongs on a court that is sworn to uphold the Constitution of the United States. And then he went further. He surfaced remarks suggesting that perhaps the law should reach into America's churches, synagogues, and houses of worship, and compel clergy to change the very teachings of their faith, not as a hypothetical, not as a thought experiment, but as a genuine possibility that the nominee had floated with her own words, in her own voice, at a public symposium. Cruz looked at all of that, laid it bare before the American people, and asked the simple, devastating question that the nominee could not cleanly answer. How can any litigant trust you to protect their religious liberty? She couldn't answer it, because there is no clean answer when your record speaks so loudly against you. What Ted Cruz demonstrated in that moment is what constitutional conservatism looks like when it is practiced with discipline, preparation, and moral clarity. He did not grandstand for the cameras, he did not reach for talking points, he did the work. He read the documents, he understood the law, and he delivered a masterclass in holding the powerful accountable.